When, if ever, should you consider filing more than one trademark application? Because as an entrepreneur or business owner who's interested in trademarks, you may be aware that there are some important limitations on trademark registrations. The scope of protection for a trademark is not everything and anything, and so it requires careful strategy to figure out how to layer trademark applications if necessary, to get the maximum protection available. So, what should you be considering if you want to layer those trademark applications? Let's talk about it. Hey, friends. Welcome back to my YouTube channel. I'm so glad you are joining me today. I'm Faith Mitten, an attorney on a mission to simplify brand protection for entrepreneurs and business owners so they can better understand their legal rights. On this channel, you will find tons of easy to understand, free, and practical insight about trademarks to help you better learn how to protect yourself and to stay on the right side of the law. As a brand owner, you may have applied for a trademark registration already, or you may be considering whether to do so. Let's start by defining what a trademark is because I want to ensure that I'm giving you a clear guide to understand when multiple trademark applications might be necessary. So, a trademark is a type of intellectual property that provides protection for a business's brand identity. In other words, trademarks tell people who the source of a product or service is, and the things most commonly registered as trademarks include things like business names, taglines, logos. But the trademark universe is pretty huge, and it can also extend to non-traditional things like product packaging, colors, sounds, building designs, domain names, hashtags, and much more, as long as these things are functioning as source identifiers. Again, pointing people to the company behind products and services. And the point of registering a trademark is to lock down your ownership over your brand identity, establishing exclusive rights to use your brand, and preventing your competitors from identifying themselves in a similar way that could confuse your clients and customers, hurt your business, and result in the loss of sales. But it's important to note that trademark registrations are not like these omnipotent saviors of your brand. There are limitations on trademark registrations, which means that the protections can only go so far. And so that's why it can be a smart idea in order to maximize your protection to layer different trademark applications on top of each other in the hopes that they will all get approved. How can you know whether you should be layering different trademark applications on top of each other? Well, there are a bunch of different scenarios where this kind of thing might make sense. Let's run through a couple of them really quickly. First, you may need to consider filing different trademark applications because of the subject matter of your trademark. There is one type of trademark application for trademarks that only include words. These are called standard character marks. And there is another type of trademark application for trademarks that include words combined with designs or words that are in a particular format or symbols that don't have any words at all. These are called design marks. There's also a different type of trademark application for things known as sound marks, meaning different audio files that have over time become synonymous or related to a particular business to identify that business. For example, the Netflix that you hear when you first open their app is a registered trademark of the Netflix brand. And there is a specific type of trademark application for those kinds of trademarks. So depending on what type of trademark you are seeking to register, you may need to submit multiple trademark applications. Let's go back to the Netflix example that I just mentioned. Netflix holds a trademark registration for the word Netflix. They also hold a trademark registration for their logo, that N, And they also own a trademark registration for the sound, like I mentioned earlier. And that is just a small piece of their trademark portfolio. But this example is just to demonstrate that based on the type of thing that you want to protect, you may need to submit multiple trademark applications. Another reason why you might consider filing multiple trademark applications is if your business or brand somehow changes after you file the first application. That change could be a slight pivot or a sharp turn in a different direction. This is true whether it relates to the products and services that your business offers under its trademark, or whether the change has to do with the trademark itself. For the purpose of explaining what I mean, let's start with the products and services and then move to the trademark itself. As it relates to products and services, trademark registrations only provide protection for the products and services listed in the registration. So if you are a cosmetics brand and you sell facial wash and makeup accessories, and those items are listed in your trademark registration, those are the things that your trademark will protect you for. But let's say that, like most cosmetics companies, you now want to pivot into selling perfume or luxury apparel. Would those things be covered by your initial trademark registration? No. There is this concept of the reasonable zone of expansion that basically says that if the items that you are pivoting toward are somewhat related to what your trademark registration covers, and it's expected that a business like yours could make that sort of pivot, then you have protection for those things, even if you didn't file a trademark registration for those new things. I tend to think that relying on the reasonable zone of expansion is a scary thing to do because what is reasonable can be debatable in a trademark dispute. Rather than relying on a doctrine that can be twisted and turned against you, it may just be beneficial for your peace of mind's sake to file a new trademark application for the new products and services that you are now offering, because you will not be able to go back and add those services to your initial application if it is pending, or the registration if it is approved. Now, relating to changes to the trademark itself. Some changes may require filing new applications. I mentioned before there are standard character marks which protect words and letters, and design marks which protect words in combinations with symbols or symbols alone. The beautiful thing about standard character marks is that there is protection for the trademark no matter how the words appear. With a standard character mark, you have flexibility to change the format and stylization of the words without losing trademark protection. The same is not true for design marks. Let's look, for example, at the Chevrolet logo, which has changed over time. Initially, the logo was in a scripty, cursive font, and then over time, it morphed into this plus sign with the word Chevrolet. Now, had Chevrolet gone from the first logo in the script font to the second logo without filing a new trademark application for the second logo, the trademark registration for the first logo would not protect their use of the second logo, because design marks must be used consistent with the design. And if the design changes, that may be a reason for you to file a new trademark application. And then obviously, if you make substantial changes to your brand rather than a tiny pivot like Chevrolet did, you may want to file a new trademark application covering your new brand. For example, Twitter's infamous and ill-advised rebrand to X would be the type of scenario where the company that owned the platform should file a new trademark application covering the new business name. A third reason why you might want to consider filing multiple trademark applications has to do with the USPTO's requirement involving use in commerce. Use in commerce is a huge and complex topic that I've covered in another video, which I will tag here and link to in the description, but it boils down to this in a nutshell. Are you selling products or providing services in connection with your trademark in a way that has some sort of reach outside of your home state? If the answer to that question is yes, then you have use in commerce. If the answer is no, then you do not have use in commerce. And US-based business owners who are applying for trademark registrations must establish use in commerce in order for the applications to be approved, in addition to meeting all the many other requirements that apply to trademark applicants. But does that mean if you haven't established use in commerce, if you haven't publicly launched your brand, that you can't apply for a trademark? No, absolutely not. You can apply for a trademark even if you have not established use in commerce. These kinds of applications are known as intent to use applications. In use applications, on the other hand, are for trademark applicants who have already launched their brands. They're selling products and services in the way required to establish use in commerce. So a brand owner might consider filing an intent to use application along with or after they have filed an in-use application to try to get some degree of protection and essentially reserve their place in line for the products and services they haven't publicly launched yet, while they seek or maintain protection for the things that they have publicly launched. The reason why a trademark applicant might want to separate the in-use products and services from the intent to use products and services is to get protection for the in-use products and services more quickly, because in-use trademark applications are processed much more quickly in a much more streamlined way than applications that are filed on an intent to use basis. And related to that, another reason that a trademark owner may consider filing multiple trademark applications is if they are testing a bunch of different things that they might want to incorporate into their brand. And this is a tactic that large brands use all the time when they're trying to vet a new product line or a service line or something. In order to prevent their competitors from getting a leg up and registering a trademark for something that they might want to use, they file a bunch of different intent to use applications to essentially reserve them. And after they do their market research and figure out what's going to resonate with the target audience, they may go all in and commit to one of the intent to use applications and then abandon the rest. And this is a strategy you may want to implement as well if you are still in the testing or focus group market research stage of a rebrand or the launch of a new product or service. No matter the reason for considering filing multiple trademark applications, it should be a part of a well thought out brand protection strategy. And a knowledgeable trademark attorney can help you prepare this kind of strategy, because while I've given you some things to consider here, this video is just a summary, as I always say. And like all summaries, I have left a lot unsaid. So for legal advice about your specific situation involving whether you should apply for more than one trademark, please do consult with your own attorney. And that's a wrap. If you enjoyed this video, please give it a thumbs up. Be sure to subscribe to the channel for more trademark content and to turn on notifications so you never miss when I post a new video. If you have thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.